So good afternoon. Hello, hello. All right. We want to get started for the afternoon session, and I will start by calling the key handbook team members. Just come and set the roll-up banners here. Can we have the key handbook team members come and occupy spaces at the round table? Thank you so much. And having said that, if you check your programs, this is the time to have the real PLO talk to us now. So I'm going to hand over the microphone to him, and he's the one who will coordinate who will lead the handbook team to deliver what they have for us. Thank you so much. Karibu, Prof.
Thank you very much. Good afternoon. Good afternoon. So we will have the following take us through this program. This is by way of alerting them. Dr. Ruth Aura, Eric Masafu, Professor Gilbert Obweyere, Evelyn Magere, Dr. Miyawa, and Robert Mutembe. But before we broke, we asked ourselves that we would speak to certain terminology in Kiswahili. Who now knows what biodiversity is in Kiswahili? The younger ones. Ni nani? The younger ones. I am assuming that most of you here are lawyers. And as they prepare, I remember I was talking to the Honorable Judge here and my good friend Professor Kameri Mbote, and we remembered certain terminologies when we were law students and talking about riparian rights. Who amongst you here remember volenti non fit injuria? Who remembers the volenti, that the maxim is volenti non fit injuria, not scienti non fit injuria? You remember those? The younger ones. Because when they come up with their judgment, I think those issues are going to come up, even as we talk about acts of God. Are you ready? Tell me when you are ready. If and when you are ready, Dr. Ruth Aura will take us through the handbook. I've just flipped through. It's a 296-page document. So it takes very few individuals, particularly of the younger generation, to go through that. And there is no executive summary, so so I look forward, after this presentation has been made, that we will have what I call the shorter edition, the simpler, the popular versions. But let us now invite Dr. Ruth Aura to give us the background. And I think what we want to do is to have the presenters do it in 5 minutes. In other words, the background, you do it in 5 minutes. Eric, chapter 1 in 3 minutes. In that way, I think you give them a flavor of it without going into the substance. Dr. Aura. In the days of COVID, she would be receiving another microphone. But COVID is no longer with us.
Thank you, Prof. Good afternoon. My voice is not deep like Professor PLO's, but at least you're awake now, yeah? Okay. So this afternoon we are going to present the handbook that we are privileged to have been supported by UNEP. And before I address you, I'd like to introduce my team. Otherwise, they will not write after here. I can see Professor Biere. And I can see Evelyn Mogere. This is the last born in the faculty, joined that recently. And then we have Eric Masafu, he's been there longer. And we have, where is Robert? Okay, we have Robert Mutembei. Robert Mutembei is a common figure, has been the project manager for FOLAP. And we have Dr. Miawa. Dr. Miawa, where are you? Sometimes late, but you will appear. And I'm also, and I am one of them too. Okay, so I'm going to take less than 5 minutes, Prof, so you should not worry. You can see that background. Does it strike you? It doesn't? You can't see anything weird about it? The way, okay, there's too much light, huh? Okay. Okay, we are here courtesy of FOLAP, and FOLAP's main mandate is to provide legal aid services to the community. And we've done a lot of legal aid work in the community, but we've not had an occasion to deal with serious issues of climate change and environment. So we came up with this idea, and actually it is not our idea alone, but it was an idea conceived by one other than Professor Mbote and a team from UNEP to serve as a resource for policymakers, as a resource for people in the community, and that's why I agree with Professor Pielo. We have an abridged version which is going to be useful at the community level. Because if you want to go and provide legal aid, you must have something to live with the community. You must educate the community. And we are not assuming Ruth is going to be there permanently, myself is going to be there permanently, or Robert and the rest of the team, or Professor Mbote will be available to give us things to do, and we're doing them in piecemeal. So we thought having this handbook was going to be a permanent creature of the faculty that would then provide guidance in terms of legal aid provision on matters of climate change and environmental justice. And then even we are not alone, because I also talked to National Legal Aid Service. They have the main mandate for providing legal aid service to the community. And this handbook will be very useful to them, because really climate change is a serious, serious problem to not only to Kenyans, to the whole world. And you can see they're already into the community addressing issues of climate change in Northeastern. So this is the reason why this book became imperative for the faculty and for UNEP. Okay, so it is not for the poorer people, the way we always say, like he said, the riparian, they don't worry about the rich ones, they always remember the poor ones. These ones we can do we can do without them. So even if we evict them, by the time they get a lawyer to address their problem, it will be too late. So we can continue with our development agenda. Okay, but the rich ones, they have the money, the pockets are flowing, maybe bursting. So if you touch them, then you know, and they can delay the system, the justice system, as long as they can. So this book becomes very helpful to the community so that they can know the ABCD. Our our nursery school teachers, they're not here, but if you can remember the ABCD, the first that you learned in school, then this is going to be that one for the community. Then it has also information that policymakers can use, even the court itself, because we have a lot of information that are cross-cutting globally and on diverse sectors. And this is the reason why we are to involve even someone from the Faculty of Natural Resources and Environment, Professor Biore, to add value to it. And the world is going multidisciplinary, so why not even us at Egerton? So I'll stop at that because I was given 5 minutes, and Prof, I think I've kept my time, and you can use it for someone else. Thank you.
Would you believe that last week this room was flooded? I was talking to the people here last week. The rains fell in the Longonot area and this room was flooded. That is how real. And I was telling Teresa here from IDLO that in her part of the world, in Zambia now, they have electricity for a maximum of only 2 hours. And even in Zimbabwe, I think, in the last 3 months. That is the reality. And Professor Kibwage was telling us about the streams. Some of us who grew partly in rural Kenya and in Nairobi, I remember, who grew up in Nairobi? Here, in the good old days. You all are rural folk. but wherever, Patricia, you'll remember, and we are saying this because, and those of you who are familiar, and many of you will be, you know, Lake Chad has shrunk by nearly 70%. Lake Chad. And the river, the Lake Victoria, if you look at it now, it is characterized as a dying lake. That is what we call Lake Victoria. I prefer to call it Narubari. Eric Masafu, could you tell us what chapter 1 does? You remember when we were watching movies, you only shown a little of it, and we used to say, this is what we used to say in Sheng, Shoni shortly. I didn't know it meant shown shortly, but we used to say Shoni shortly. So Shoni shortly. Could you kindly show us shortly what chapter 1?
Many thanks, Prof. Let's just set up. So yes, maybe we'll start off as we wait for Robert to bring up the PowerPoint. So chapter 1 basically gives us the introduction to the handbook. As Dr. Ura has said, there's so much that has been covered. So we've taken a look at legal texts, case studies from an international perspective, regional perspective, and national perspective. We've borrowed from government and intergovernment reports. So the document itself is quite rich, as you'd see in the abridged as well as this big version. The structure of the book itself has 10 chapters, so it has 10 chapters. So it cuts across various sectors on environment and climate change or climate justice. So as you'd realize or know, the legal framework governing this area of the law is quite complex. So what we've tried to do is simplify it. So you'd see if you pick MCA with its regulations, there are quite many. You go to the water sector, you have the Water Act. You go to the forest sector, you have the Forest Conservation and Management Act, the Wildlife area, Wildlife Conservation and Management Act. You have an Energy Act, you have a Climate Change Act. So there are so many, there are various acts, and at times they're in conflict with each other, so those are issues that we've raised. So maybe just to give a brief on the introduction. If it is okay, the introduction essentially, most of the things in the introduction you'd see are definitions that have been given, which have been highlighted here. A historical perspective. You heard about these issues started from the US, so you'd see definitions, a historical perspective of how the climate and environmental justice issues have been have started. Then there's some aspects on multidisciplinary. As you've seen, this is not just a legal issue. So we've had discussions, we've combined science, law, human rights. So you have people contributing from just not the legal field, but the arts field, science field, so that you have that multidisciplinary aspect on it. Then, of course, in all of the chapters, there's always a conclusion and takeaways, which you'll also find more of a summary of each chapter. After each chapter, you'll see conclusions and takeaways, so just a brief of that chapter. So as you've been told, it's a 295-page document, so I'll let Professor Buyole pick up from there. He's not from the legal field, but he'll expound on it.
Thank you very much. You know, when we were having a conversation with the good old judge, one of the things, the case, the Il Chamus case, and Professor Mbote reminded me that this idea of act of God, we must now begin to rethink it, because there are certain things that can actually be contemplated. And when I see the linkage between science and climate change, it means that those in the judiciary must now ask certain questions which hitherto were never asked. And this, I think, is very important in terms of breaking it down. And I hope that the environment clubs in primary schools, in high schools, and in the universities will interact with this handbook. And when they interact with this handbook, they'll then be able to think differently. We were reminding ourselves over lunch when we were taking photographs that perhaps we humans misunderstood God. Those of you who are Christians, I want you to go and read Genesis chapter 1, verses 26 to 31. When God and the other fellows who are sitting in heaven, they said, let us create man in our own image and let them have dominion. And I think it is this dominion that we misunderstood. And that's why we are messing up in the manner that we are. And you, Professor Gilbert, must now tell us what we must do. You are dealing with chapters 2, 5, and 10. And remember the word that Professor Mbote talked about, polycrisis.
Okay, thank you, Prof. We will go systematically. I will come back for the other parts, but I would like us to go systematically so that we go through the book. I'll come back for chapter 5 and 10 at a later time. And I'll take a second to introduce another member of this team. I know lawyers sometimes forget the most important things. And Kioko Kivandi is also a member of this team that struggled with this from the journalism side. So thank you very much. I'll quickly take you through the chapter 2, which gives us a global map of climate and environmental justice challenges. And we have divided this into 3 groups of 4. The first one is the climate change challenges, or challenges that are directly emanating from a changing climate. And that is issues like extreme weather patterns, like what Professor has just described about flooding of this room a week ago. Melting glaciers. Those of you who are mountain climbers, if you go to Mount Kenya today, you may not see the glaciers that were there a few years ago. About 28 or 30 years ago, I went up to the Muland on Mount Kenya, and we could see the glaciers, but right now they are not there. Sea level rise, it's been alluded to here. Even lakes are rising, forget about the sea. Lake Baringo is up, Lake Bogoria is up, Lake Nakuru is up, Naivasha is up. Almost all the Rift Valley lakes have their levels up, and this is a great challenge to humanity and also to nature. Then ocean acidification, I think those of you know coral reefs. If you go down there, you might find discoloration, which is impacting negatively on the marine ecosystems. Then climate-induced migration. We're just talking about those people who have been moved from the riparian zones. They are moving either forcefully or they are moving voluntarily, though grudgingly, because they can't bear the brunt of the water. And this is great challenge. Then we have a section that looks at the responses and the climatic change impacts. Then we have environmental degradation, where we are looking at pollution in terms of air, water, and the marine environment. And we also have a section that looks at the responses. Then land degradation, we are looking at those of you who come from Nakuru, you've witnessed sinkholes and fissures of enormous magnitude within the last few months. And they are causing a lot of fear and a lot of some sort of, I would call it, people don't know what to do. They don't know even what is happening. So that is very critical. And then we have issues of structural barriers in terms of movement. You're looking at the landscape. I think about 2 weeks ago, we had a big rainfall in Nakuru also. And a priest was actually carried off a motorbike and was killed about 3 or 4 weeks ago. So we are looking at all this, and we would like to get people to understand that climate is real, climate change is real, and it has impact on our lives. And as we look at this, we are looking at what does it do to the population. And from our background, we don't just look at human beings alone. There are habitats that are being lost. There are niches or roles of different components of the environment that are being lost. And very soon, what you like eating may not be there. And therefore, you'll end up missing your nice potato, missing your nice honey, because the bee doesn't have the habitat which it lives in, because Lake Baringo is flooded, and the plants that produce the pollen that the bee feeds on are no longer available. So it might not be as direct as somebody being moved from the riparian zone of Nairobi River, but it could be indirect in terms of affecting our food situation. So these challenges are real, and we are bringing them forth so that we can understand them and therefore find solutions, especially where we are talking about justice. Do the people who lose their habitats, do the animals that lose their habitats have a recourse? And how do we attend to this? Thank you.
Thank you very much. Evelyn, could you kindly do chapters 3 and 4? And as you are coming, what is wetlands in Kiswahili, the younger ones? Ardhi oevu. Thank you very much. Evelyn, 3 and 4. And then Gilbert, you come for 5.
Good afternoon. So I'll just take you through chapter 3. Chapter 3 and 4 are focused on the environmental governance system. Chapter 3 is more on the global level, and chapter 4 looks at the Kenyan system. So we consider chapter 3 like something like a tour guide, taking the learner of environmental justice through a very complex terrain, which has principles, frameworks, mechanisms, institutions, and all sorts of things which they might not be familiar with. So chapter 3 is essentially that. So it has three main. We've divided into 3 main parts. The first one is the principles of environmental governance. These are general principles that shape environmental law, both internationally and nationally, not just Kenya, but in general. National environmental governance systems are shaped by these principles. We look at them in greater detail. Obviously, we'll be able to do that here today, but we've grouped them into 4. There are those preventive principles, which is not the same as the principle of prevention, but a group of principles that have been designed to prevent environmental harm. Then there are those which are more focused on accountability. Then there are those which are designed around equity, and others. We also look at emerging concepts. We had Professor Mbote mention some of them, like environmental rule of law and others. We look at them in that first section of chapter 3. Then 3.2 now goes into the mechanisms, the international environmental mechanisms. Again, Professor Mbote did us quite a favor. She went into a lot of that in her keynote address. So we look at the frameworks that the global community has come together to put together to serve as a framework to guide the world on how to respond to environmental degradation and climate change and its impacts. We look at the policy frameworks, the institutional mechanisms. So the different institutions have been set up under what we call the multilateral environmental agreements, the MEAs. So those are the frameworks, and under them we have secretariats, we have conferences of parties, and we have other mechanisms that make sure we don't only have the frameworks which set the terms, but we also have implementing mechanisms, okay? Then we have funding mechanisms, so that's under the MEAs. We also have institutions that are not exactly under those MEAs, but are quite important to environmental governance globally. So we have the UN system, which have, of course, we have the UNEP, and we have other institutions as well which have a key role, and we also have international finance institutions which provide funding and all that. And we have regional systems. We have regional systems under the AU, systems under the East African community here, and even mixed regional systems that we have, like between East Africa, COMESA, and IGAD, tripartite system. So that's the second part of chapter 2. And the last part, we look at Kenya's place within this complex terrain. Essentially, we're just looking at what has Kenya done here, what role has it played, what leadership has it provided in what areas. So that's chapter 3. And then chapter 4, now we go into our own Kenyan system. We start with our obligations and our international and regional frameworks. And then after we're done with that, now we go into our own national system, obviously starting with the Constitution. We look at what it is that our Constitution says about environmental governance in Kenya. We look at the relationship between the Constitution and the legislative framework, the laws that we've put in place. specifically for the general law for the environment, for climate change, but also sectoral specific laws for different sectors like water, energy, forest, wildlife, things like that. All of that is under the legislative framework. We look at the policies that we've set up in Kenya. We explain how all those work together as a system. Okay, then we go into the institutions that we set up. The ones we set up under our constitution, the ones we set up under our statutes, our legislative framework, and even our political institutions like the Ministry of Environmental of the Environment. So that's chapter 4. We also look at the principles, those general principles we talked about in chapter 3. We look at them again in chapter 4 in terms of how they are applied or how they manifest within our own governance framework. And then, as my friend Eric said, we do, for all our chapters, for our first 7 substantive chapters, we do a conclusion which recaps the points that we've made in a much more accessible form, simpler form. And then we give recommendations for how we give the relevance that learning this has for environmental justice. So what opportunities are presented both within that system, and then the challenges that we explore in the chapter that exist within the system for environmental justice. We look at what opportunities are there to take environmental justice action for those who are interested in that. So that's chapter 3 and 4. Thank you. Very much. Okay.
The judge is confirming to me that he'll ensure that judges in his division go through this book very thoroughly. And one of the things that is coming to my mind that in the early days, use amicus curiae, particularly when you are dealing with these issues. Make it a standard thing so that they can address the court for not more than 5 minutes on critical issues, which you will have defined for them. Chapter 5.
Very much. Chapter 5 delves into environmental planning and management tools. And I think this is very relevant, especially for those institutions that will be undertaking environmental planning and management, especially the county governments, because most of the environmental issues are actually devolved to the county level. And in this chapter, we look at the tools. For example, we are looking at the National Environmental Management Plans. We are looking at the environmental and social impact assessment tools. We're also looking at geospatial tools like use of GIS and remote sensing in issues of environmental management and planning. We also look at processes. How do you undertake to come up with an environmental management plan? Who is supposed to be consulted? Who is supposed to participate? And who is supposed to give information all the way to the implementation of such plans? We are also looking at environmental audits. Who should be able to carry out environmental audits? What processes go into environmental audits? And what tools do we use for environmental audits? And when we talk about environmental audits, we are looking at a holistic approach to all sectors that impact on the environment and to the well-being of the inhabitants. Then we are also looking at environmental management systems, especially for those who interact directly with the environmental processes. We are looking at manufacturers, industrialists, and any other service or goods providers who intend to have good practice in terms of environmental management. This is an equivalent of the management systems for human resource, but in this case we are only looking at the environment. Then we look at environmental monitoring. I think this is the most the weakest point in Kenya in terms of environmental management. We have infrastructure in terms of legal and policy provisions, but the implementation is the weakest point. Because some of the things we are seeing in the environment today would not have happened if monitoring was done. So we give a glimpse and a very good annotation of how environmental monitoring should be done, including reporting. Because I think what we have done very well sometimes is just to monitor, but we never report. So we don't know exactly what is happening. People don't know when such things are going to happen, and we are caught flat-footed sometimes when environmental challenges strike. Then we also look at the challenges in implementing environmental management tools. Some of them are expensive. For example, if you are to use GIS, you have to employ technology. Initially, this becomes expensive, but in the final analysis, whatever we get out of the process that we undertake may save us quite a lot if we can do early predictions of what is going to happen in the environment. And we, as my colleagues have also mentioned, we cap up this chapter with a conclusion and takeaway messages. I think I want to stop there and have the next presenter.
Your chapter 6.
In chapter 6, we delve into the legal basis of environmental rights. So in that chapter, we are basically addressing the constitutional basis. Then we also have a statutory basis, so various pieces of legislation that have an underpinning or touch on environment addressed. Also international treaties and conventions that Kenya is a party to are looked into. From there on, again, we look at now the substantive, that would be the substantive aspect. We also delve now into the procedural aspect. So if an environmental issue arises, how does one take charge? Where do you report? How do you go through it? You know, we've simplified it for the lay person, and also if you're a legal scholar or a student, it would be extremely helpful. We also look into case studies at the international level, regional level, and locally, and how they've applied those various constitutional and statutory provisions in the various environmental litigation that we have faced. And then, of course, we do a conclusion and a takeaway. That would be the chapter 6 was basically about rights and indigenous persons. So Mr. Maxwell Miawa will pick up.
Mr. Miawa? Dr. Miawa, you around?
Dr. Miawa.
Talking about rights, I think the most important critical institution that plays a role in the advancement of rights is what we call social movements. Chapter 7, I think it's wrongly titled, they have called it responsibility, but I think in lingua franca we will revise it and call it social movements, which is a broader category. It's a much, much broader category that includes you and me, everybody who is here, political parties, grassroots mobilizations, women groups, student leaders, political leaders, and so forth. One of the critical roles that they do play is what we call creating resistance in national and international law. And resistance does not necessarily mean opposition or oppositional politics as we know it. It means creating alternative ideas, okay? And part of the other roles include what we know very well, creating awareness from below, community counterplots, or another one which is much more complex, how they institutionalize radicalization. And again, radicalization here means alternative ideas, whether we are talking about in government or non-governmental institutions. And also, they radicalize institutions. So we also look at how they radicalize institutions in the sense of how they make institutions to even go beyond, far much beyond the conventional, the orthodox. And other strategies such as, basically, we look at the role and the strategies that social movements use. And I've said social movements is a much more broader category. The language that they know is always civil society or in NGOs, but I think here we want to move away from the NGOization of language when it talks about even individuals who act in their own right. I personally, I can call myself a social movement because I've instituted an environmental justice case in my own name somewhere in Kisumu against an international, transnational company. So I fall within that broader category of how we challenge institutional and non-institutional. Yeah, and of course we also highlight one of the challenges that these institutions face in the contemporary Kenya today. It is the emerging culture of abductions. We have seen social movements being abducted, particularly when they're trying to create resistance in national law, challenging the government, asking very, very serious questions. So some of those challenges, we highlight them there. And I think that's what chapter 7 basically deals with. I will cover much more of this when I present my paper.
Very much, Mutembe, chapters 8 and 9.
Yes, thank you. To chapter 8, 9, and 10, basically we are covering citizen guides. So just go back to chapter 8. So in chapter 8, we have various guides, and in chapter 8, we are concentrating on a guide for citizens on how to detect and report violations. So just basically picking from all that we have gathered from all those other chapters, and now we are addressing the citizen and giving them a guide on how to report and how to detect and report violations. If you go to chapter 9, we have another guide, action guide, and this is on how to seek legal redress, and it touches on some of the avenues that we have already had in this forum. Litigation, including private litigation, public interest litigation. It also addresses how to seek redress in international forums. We have addressed the East Africa, African forums and the UN systems. And then to chapter 10, we have another guide for monitoring. And I will invite Professor Biere to conclude and make closing remarks on this. Thank you.
Thank you. Don't get tired of me. We are looking at monitoring, and we would like to empower all our stakeholders in this section or in this sector to be able to do monitoring at all levels, from a personal or individual perspective to a group, community, or all the way to a national level. I think we have monitoring tools that have been developed for monitoring environmental challenges. We can be able to predict and even determine early warning systems so that we can be able to say what is likely to happen. And we would like also to have a preventive approach to environmental and climate justice, so that are we able to prevent occurrence and avoid litigation. If the communities can be able to monitor their environment and report, then we are likely to dispense off with some of these issues at early formative stages before they become violations or before they are escalated to a greater landscape level. A case in mind is we are working, for example, in a small watershed in Nakuru called Rivarongai. And in Rivarongai, we have flower farmers. We have people who are doing tomatoes, they're doing cattle keeping and so on. But then somebody is quick to say the flower farm is the one polluting the river. But there's somebody else who is saying it is the onion farmer or the tomato farmer who is putting the packages of either herbicide or pesticide into the river. If these people can be brought together early enough and they monitor their environment, they can be able to address this issue early enough before they reach Lake Baringo where the fish will be dying. So that we don't have a big chain of violations, rather than we can be able to address them as and when they first appear. So monitoring is very critical, and we need to use science, in this case, to provide evidence. And this is not complicated science where we need microscopes and all that, but we can empower the communities to actually use what they know in their communities. For example, if you're looking at a river system, Professor Kitaka is here, I might violate some rules, she can correct me. There used to be some small insects that would go round in the water. And the girls of my age and backwards used to pick this small insect and put on their teats for them to grow. I know there are a few of us who can resonate with that. But if you don't see these insects, then that river is polluted. It's a bio-indicator. So these are some of the things we want to use to show that things are changing and take action. If you go to pastoralists, for example, if they slaughter a goat and they look at the offals, they can easily tell you when it is going to rain. This indigenous knowledge can be used to offload, and they can even tell you the amount of rain that will be. So we can be able to say there's going to be a flood very easily and move people early before the floods come. So we are looking at how monitoring can be a tool that we can use to preempt lengthy court cases like what our good judge is going through with Lake Baringo and the Ilchamus. Maybe that's why the people are complaining that we did not tell them early enough to move their property. If we did this through a monitoring process, I think we'll be able to dispel off some of these issues. So that is the context in which monitoring is presented in this book. Thank you.
You know, a handbook is like the Bible, so it can only be, you'll be using it on a daily basis, a Bible, Quran, or the Hindu Gita. So the fact that it has been presented to you is just to whet your appetite. And I think it is a document that the courts are going to use very much on a daily basis. And as you've already said, there is the abridged version. I look to the day to the forward when it will be in Kiswahili. And beyond Kiswahili, even in the local languages, who amongst you here is from the Gikuyu nation? What do you call land, wetland in Gikuyu? Not Professor Mbote, somebody else. What do you call? Who is from the Luo nation? What do you call wetland in the Luo? Thithia, you got it. And Kikamba, was there what do you call it? You know, these are, because if you go to Nyumba Kumi and you are using it at a chief's baraza, you'll need to tell them in a language that they resonate with. So you've listened to the presentation. Can we just have 2 reactions? Quick. It's a draft, so I believe that you invite inputs. If people are then exposed to it, yes, good doctor. Could you kindly move the microphone, please? Yeah, you are loud enough. But I believe they want to record what you are saying, so you may need the microphone.
No, it's just to thank the Egerton Faculty of Law team for putting this together. And I think the publication is timely. I only have two comments. One is on social movements as presented by Dr. Miawa. I don't know if the book will look at challenges to the effectiveness of social movements. One thing that stands out in Kenya is the issue of civic space. I don't know if you'll interrogate how that will constrain or enable social movements to pursue environmental justice and what solutions you could provide, especially for those grassroots environmental human rights defenders and make their work a little bit more effective. Then on citizen science, I think that's what was presented by a good professor, collecting data from citizens. Again, we also experience inordinate obstacles in terms of recognition of citizen-generated data as credible data to inform decision-making and action. So maybe that's something that if it's not covered, probably you may want to look at it. And I say this having not read the guide. So thank you.
Thank you very much. Professor Kitaka, you wanted to say something.
I have several citizens who are actually doing science, but the question is adaptability of that information on the legal systems. And even also, like for example, I run labs, but when I have issues of environmental, I have to tell my client, take this one to that lab in Kisumu, because that's an accredited lab. This information cannot be used in court, whereas actually some of this information, even coming from student theses, like for those who know, recently the fish was burnt in Lake Nakuru. That was actually from a thesis of our student, who wrote a thesis, and we realized the ecological aspect was so high. And when the paper came out, we actually wrote a paper. When it came out, everybody was like, what is this? So the government institution ran around, found it's the same. But I'll tell you the impact that has had now, we cannot access that lake. I wanted to do something there, and we are like, you can't come to this lake. Now we have to get permission from so-and-so, simply because we brought up an issue. I think also research needs to be part of justice. And therefore, that is an issue I was going to bring it up. Now, the other thing in terms of emerging issues, I don't know, I think it was on, chapter 3, on where is global politics? Because global politics is key when it comes to climate change. I don't know whether it's part of the emerging issues, because I've not read it also. But I think it's something like, now, I just want to give an example. All of you know Netherlands just did election the other day. As you are aware, they don't have a government. I was telling them, you are learning very quickly from us in Africa. And therefore, what has happened? There's no funding of anything. And all the projects which were supported from the Dutch government in terms of climate change have all stopped, have all stalled. SNV has actually walked out. So where does this leave? If, for example, we are talking about financing, and we are people, because I was in the field, people are so interested in this carbon financing credit. So maybe there was an aspect, where do you leave that community? Maybe if that was the source of money. We know what happens in the America. Some of them don't believe in climate change. So I don't know how that can be taken in terms of how do you cater for this when it is already happened? And it's happening again very fast. A good example I said is Netherlands as we are sitting here now. Okay.
The guide, don't contribute. What I urge you to do is to spend the next 2 days, just browse through it. And if you have any thoughts, then you can send them, and the rapporteurs will take, so that your contribution is informed. Otherwise, you are in danger of exposing some things that you may have found there. So I excuse the two of them, but I believe I've browsed through it very quickly, and it looks very good. And I believe that we'll benefit from it. I believe that brings us to the end of that presentation, which then will allow me, because I am not properly guided, but the next session is the session that now brings in adjudication in climate and environmental justice, the evolving role of courts, and Professor Gudrun Zogel, Professor, did I get the pronunciation right? And then Dr. Wambua and Dr. Miyawa. I believe you are, Professor Gudrun, you'll lead with the presentation. Of course, the notional allocation is 5 minutes, but you can have an overrun. That keeps, of course, but you can overrun a little. I know you are prepared for 20 minutes. I believe somebody else is supposed to chair this session. Is it you? Yes. Oh. Okay, thank you very much. Good professor, you may present. Of course, we will not stop you unless you are like a Pentecostal preacher.
Okay, good afternoon. Thank you very much, Egerton University and Professor PLO for facilitating that process. The handbook, and will be shared with us, is, believe the idea is that we look at it. We have our many comments. The idea is to improve, and I believe comments and responses would be well taken in. I believe Egerton will tell us where to send our views and comments about it. As Professor Pielo has said, we are going to get into discussions, presentations by different professors and scholars in different fields. We have categorized them thematically, and the first session, which I am the discussant, will be adjudication in climate and environmental justice, the evolving role of courts. We have been speaking about courts since morning. Okay, and to start us off is Professor Goodland. Monica? To talk about the European Court of Human Rights and the litigations around climate change coming from their lessons and jurisprudence we could take. Thank you very much. And Professor, you're welcome.
Thank you very much for the kind introduction. So my presentation today is about the three climate judgments, the first three climate judgments which the European Court of Human Rights has released in April this year, and they were very much awaited because there have been climate cases brought to the court since the 2020s, but so far there was no decision. So in my presentation, I will briefly introduce the three cases and then look at the procedural issues, because most of the problems we find in the procedural fields. Then briefly look at the substantive questions, and then look at the question of whether climate litigation is a means to, or climate litigation before the European Court of Justice is a means to enhance climate justice. Okay, can you continue? Thank you. So let me first briefly give you some information about the European human rights system. The European Convention on Human Rights and Freedoms was adopted in 1950 within the framework of the Council of Europe. It has 46 member states, so all EU member states, and then You see several Eastern European countries and states not parties of the European Union. In 1959, the court was established. Until 1998, the individual complaints procedure was not mandatory, so states had to subscribe to it. But since 1998, we have a mandatory complaint procedure. The court has released over 25,000 judgments since it started operating. The caseload has increased, so it has been more than 3,000 in 2023 alone. The court receives over 70,000 complaints every year, and currently about 62,000 applications are allocated to one of the judicial formations. So the cases I want to talk about today are the following three cases. I think one was mentioned in a previous presentation. You mentioned it. The court actually has received more cases since 2020, but has put on hold them to decide these three cases to kind of get a common approach to these climate questions. So what are the cases about? Let me briefly introduce you to them. Der Verein Klimaseniorinnen, this was a Swiss association representing over 2,000 elderly ladies, so from 70 and older, and to basically fight for the human rights affected by climate change. So this association and 4 members of the association, ladies over 80, brought a claim against Switzerland that they didn't do enough to prevent climate change, and so they would suffer from increasing heat waves and so on, and this would affect their human rights. The second case was a French citizen, inhabitant of a French town at the Atlantic coast, and he complained for the same reasons. So his city faces the risks of climate change-induced flooding, so something you know here as well, in the period of 2030 to 2040. The third case also affects a vulnerable group. This is 6 Portuguese children and youth, and they complained against Portugal and 32 other European states for not doing enough to combat climate change, and this would affect their human rights. So all these cases were put together in the Grand Chamber. The same chamber decided about these cases, and they were decided, as I said, on the 9th of April this year. The first hurdle which all of these cases have to overcome, and 90% of all the applications fail because of admissibility hurdles. So we do have several requirements here, and 4 of them the court addressed. First of all, the question of standing and of the victim status. So are the applicants personally and directly affected by the state's inaction regarding climate change? The second question, or the second requirement, is that it's a violation of a convention right by a contracting party, and here the question is whether climate change effects are attributable to a party and whether the state inaction is causal for the adverse effects of climate change. The third question is extraterritorial jurisdiction, namely, are states responsible for adverse effects of their greenhouse gas emissions in other states? And the last question is, of course, the exhaustion of local remedies. So the first requirement, can you? Yeah, right. So the first question was a question of standing. and this was mainly decided in the climate change, in the Klimasenioren case, in the Carême case. To be able to bring a claim, you need to show that you are personally and directly affected by a certain state conduct in your human rights. In the Carême case, for instance, this victim status was denied because the risk of Mr. Carême was hypothetical in nature. Mr. Carême moved during the proceedings away from the city to Brussels, where he became a member of the European Parliament, and so the court denied the victim status because he didn't have any more property in this city. The case was different when we look at the Klimaseniorinnen, and here the court made some kind of spectacular decisions. So first of all, he said individuals must be directly and personally impacted. However, in the case of climate change, we need more than that, because basically all of us are impacted by climate change. So individuals only can bring claims if there is a high intensity of exposure to the applicant to the adverse effects of climate change and a pressing need to ensure the applicant's individual protection. In the case of the 4 ladies, they showed all their medical statements and they couldn't leave the house and it's very hot and so on. But the court did not recognize that they are victims. Because they basically said, well, everybody is affected. In Switzerland, they have possibilities to stay in the house and protect themselves. The really surprising part was the question of associations. Yeah, so this NGO, this Klimasenioren NGO, fighting for the rights, or for the human rights affected by climate change. Because here we have 3 challenges. First, NGOs usually do not suffer or are not affected by climate change or by human rights violations. Second, the victims of the organizations were not considered to be, or the members of the organization were not considered to be victims. Yeah? And third, the European Court of Human Rights prohibits actions in the general public interest. So this is clearly prohibited. You have to show the victim status. Still, the court argued climate change is so important that the role of the association is essential to bring climate change litigation forward. So they say collective entities are play an important role in fighting against climate change, because we cannot rely on all the individual complaints. In brackets, of course, the court would be flooded with such complaints. So the criteria is still, the association must be lawfully established, the purpose must be to defend human rights against climate change, and third, they must be generally qualified to act on behalf of its members. So in this case, associations can bring claims of associations are admissible, and this was the case in the Klimaseniorinnen. The second question, and I guess I have to rush a little bit now, is of course the argument we always see, the climate change effects are not attributable to a state, and the greenhouse gas emissions of one state are not causal for the climate change disasters, so to speak. So the court clearly rejected this drop in the bucket argument. So, and the court basically said every state has accepted certain international obligations to reduce greenhouse gases. It's scientifically proven that if we do not reduce greenhouse gases, climate change adverse effects will get even worse. So it is very clear that there is a causal link between greenhouse gas emissions and the adverse impacts of climate change, and also the state's inaction in this field. Another question is, and this is quite interesting, the scope of states' jurisdiction and extraterritoriality. The children, the Portuguese children, argued that they suffer from greenhouse gas emissions from all the other 32 states. So usually, if you have standing before the European Court of Justice, you need to be under the jurisdiction of a state. Yeah? So a state must exercise jurisdiction and control about you. That's territoriality. We have certain cases where extraterritoriality is recognized. For instance, if you are in Kenya in the German embassy and you're not well treated, then this would be a case of extraterritoriality when you can bring a complaint. So the Portuguese children basically argued, we are affected by the greenhouse gas emissions of these 32 states. For that reason, these states exercise jurisdiction over us, and we can have a complaint of them, against them because they do not properly act against climate change. This was refused by the court, which is very clear because this would be accepted, then the court would become a climate litigation court, because then basically everybody worldwide could bring claims against all the European states to hold them responsible for their greenhouse gas emissions. And the court said this is beyond the scope of interpretation of its mandate, and for this reason the court didn't accept this. It did, however, accept the jurisdiction against Portugal, but in Portugal, the kids did not exhaust local remedies. What does this mean? Usually, you have to exhaust local remedies to give the states a chance to fix their own human rights problems. But the Portuguese children argued we cannot bring or exhaust local remedies in all the 32 states, so we go to the court directly. Now, the court said that the children should have exhausted the local remedies in Portugal, because they also have, similar like Kenya, they have a right to a clean environment in the constitution, they have legal proceedings in place, and they also have legal aid proceedings in place and proceedings to speed up ongoing proceedings. This means that Duarte and Carem failed. Also the Klimaseniorinnen failed to a large part. But the Verein Klimaseniorinnen, so the association's claim was admissible. And interesting now is that the case that the court decided on the merits. Can you, yeah, okay. So the claim was based, or usually all the environmental claims and the human rights and the climate claims are based on Article 8, on the right to private and family life. We do not have a right to a clean environment in the European Convention on Human Rights. So usually the argument is that if states do not protect the environment or protect us against climate change, then our private and family life is affected. And this is why the court is having jurisdiction in the first place. So what did the court say in this case? And this is quite interesting. So states do have to take positive action to ensure that individuals can enjoy this right to private and family life, and this also requires positive action to maintain a habitable environment. And Switzerland, states enjoy a margin of discretion. This means states are flexible in deciding how to best implement these obligations. But this margin of discretion is narrow in case of climate change, and this is new, because the problem is so grave. And then the court looked at the Swiss way of implementing its climate change obligations and really showed some very critical lacunae. So first of all, the court has missed its own goal, Switzerland has missed its own goals several times. Then they did not look at the carbon budget they still have. Yeah, so it was very clear from the IPCC how much you can still emit and what would be the part of Switzerland. They did not do this, and there were several other aspects. Moreover, talking about legal remedies, this was mentioned as well, Switzerland does not have any legal remedies to enforce these climate policies. Okay, so what's the effect of the judgment? And this was basically the only judgment where the court decided that there is a violation of private and family life through the inaction of Switzerland. So Switzerland must bring the climate measures in line with the criteria established in the judgment. It needs to permit associations to bring climate-related claims, and it must review its climate measures. The implementation of the judgments of the European Court is monitored by the Council of Ministers in the Council of Europe, so they have to report every 6 months whether they have done enough to implement the judgment. Interesting also for climate justice is that the court may award damages. Yeah? So if you bring a claim and you win the case, then your state has to pay damages. What are effects beyond the judgment? So we know now the main views of the court in other climate judgments, which are now in the process of being decided. And of course, all the member states of the Council of Europe will try to adjust their climate policies according to these principles. So what is the achievement for climate litigation? The court has recognized the importance of climate change policies for the enjoyment of human rights, in particular private and family life. The court gives the right to associations, and I think this must not be underestimated, to really bring such climate claims without having to show the victim status. And the court has established guidelines for effectively implementing climate change measures. The last question probably is the European Court of Human Rights, climate litigation, an adequate instrument to achieve climate justice? Yes, it may help especially particularly vulnerable groups to identify their needs and bring a claim. Yeah? It gives the possibility to associations, and we will see a flood of climate applications now in the court. However, we do have some problems, of course. The exhaustion of local remedies means that you have to go through national proceedings, which will take several years, and then the court's proceedings, if you look at these cases, it took 4 years, and this was a priority procedure, so overall it will take 10 years until we see a judgment, and this can be very long, especially for very vulnerable groups. The second problem is, of course, that these judgments only create effects between the parties. But what we need for climate change is, of course, generally applicable government measures. So the role of the court here can, of course, be a role to speed up, but it cannot do it alone. Thank you very much.
Thank you very much for your presentation. We will handle that section on courts, the 3 presentations. We'll have a few comments and questions thereafter. I think we were
were well taken care of during lunchtime. All indications suggest that we may need to rise up a little bit. The media team has some exercise for us. The idea is you are to do what is projected on the screen. Media, if we could please go ahead. Okay, so we are going to try and follow. Please, if we can start once more. People have now an idea of what is to... Please, can we start that once more? The Gen Zs can get more creative. Let's start again. Okay, let's go. Okay. Thank you. Thank you very much, media team, for being creative. Like we said, this is a collective action. The problem is so huge, we cannot deal with it individually. Now, I will welcome the second presenter, Dr. Ambua Kituku. He'll be talking about carbon disputes in Kenya, a review potential judicial responses and interventions. You have 7 minutes, strictly. We will assign a timekeeper somewhere. Okay. We have looked for a very creative person who is very good in drawings. So by being firm with time, they will also be creative to keep it nice. Okay, thank you.
Okay, I'll try my best. Sometimes I can go on and on. I'll also try and make this as colorful as my shirt. As you may know, Kenya adopted legislation governing carbon markets last year, and this year the country also enacted regulations to operationalize the carbon market. And that legislative effort is perhaps in recognition of the fact that Kenya has been a leader on not just climate change legislation, but also on operations of carbon markets. In the voluntary carbon market, Kenya is now the leading generator and seller of carbon credits in Africa. We overtook DRC last year. In the regulated carbon market, Kenya accounts for 10% of the regulated carbon projects under the Kyoto Protocol, now under Paris Agreement. So with the enhanced legislative initiative in this area, it is expected that litigation will follow. And therefore, this paper seeks to answer the question, what kind of disputes are likely to emerge related to the carbon market, and how will the judiciary intervene? So the paper is anchored on the environmental rule of law paradigm as discussed today. So just looking at the overview of climate change law and policies, there are over 3,000 climate change laws globally, and this data is accessed from the Sabin Center, which is run by London School of Economics, as well as Columbia University. Kenya is among those few African countries that have a climate framework law. Now, looking at the state of climate change litigation, under which carbon dispute resolution is anchored. First, definitional issues. Yeah, climate change. Could you please move to the third slide? Yeah, third. Yes, yeah. Full screen could also help. Presentation mode, yeah. So I hope my 7 minutes are intact. Otherwise, we shall go to VAR. Okay, yes. So, yeah, next slide. So, the next one, please. So, climate litigation, climate change litigation has been defined as a case where mitigation, adaptation, or science of climate change is a material issue of fact or law in a particular case that's before an adjudicative authority. So then carbon disputes would definitely fall under climate change litigation in the sense that it's a dispute that arises from how the carbon market is being operated, or instances where there is a violation of carbon rights, which are now defined as rights accruing from benefits that are emerged from sequestration or storage of carbon. So as at 2023, there are over 2,000 climate change litigation cases globally, but a big chunk of these cases are reported in the US, about 70%. So, and the rest are largely from Europe. So there's been a concern that there could be a global north bias in how these cases are reported, and therefore that also affects how we analyze these cases. And hence the need probably for us to report a little bit more on cases in the global south, particularly in our jurisdictions like Kenya. However, these cases, it has been argued that a majority of the decisions have actually been pro-climate action. And these decisions have raised awareness on the climate change as a problem. They've also resulted in or triggered action from government, from corporations, and they've also increased ambition for climate mitigation as well as adaptation. So what is the status of climate litigation in Kenya? Kenya is among 5 African countries that have produced decisions on climate changes. The other countries are Namibia, Uganda, South Africa, Nigeria. Yes. So, the climate change litigation is also anchored in our public interest litigation on environmental issues. And if you recall, the first publicized case, Wangari Maathai versus Kenya Times Media Trust, where the court rejected this petition on the grounds of lack of locus. We've moved miles ahead. With the enactment of MCA, the issue of locus was sorted out. Now, any person can sue where there is an infringement of their right to clean and healthy environment. With the enactment of the Constitution in 2010, that right has been enshrined. It's now a constitutional right. Locus is also constitutionally protected, and therefore, there's been more progress. With the enactment of the Climate Change Act, this has also given impetus for people to claim climate change rights as a matter of legal entitlement. Now, the few cases that have been reported fall under three categories. One is cases that seek to have climate considerations integrated in decision-making, and a good example is the Save Lamu case, which I'll not get into details. Yeah. Then there are cases that also look at enforcement of, time is up, 7. Okay, then there are cases that look at the obligations of government, enforcing those obligations to address climate change. And then lastly, we've seen cases around public participation, which is a novel category that so far has not been articulated in literature on this subject. We also have cases at the East African Court of Justice. Now, looking at the possible disputes that will come to our courts, so I looked at about 7 issues, and I'll quickly rush through them. So if you could go back to issue 1. Issue 1 is there's likely to be disputes arising from adherence of carbon projects, yeah, on the sustainability principles that are articulated under the Climate Change Act, as well as the Paris Agreement. And of course, one criteria is the human rights criteria, that the projects should not violate the rights of communities where they are anchored. And then also, do these projects contribute to sustainable development? So we anticipate a lot of litigation around there. The second issue is who owns the property in carbon. If you could move to issue 2. There has been contestation. These projects are established on private land, community land, sometimes public land. So if the projects are on private land or community land, who is entitled to those credits? Is it the landowner? Is it the project proponent? Yeah? Or is it the ultimate buyer of the rights? And if the projects are implemented in community land which county governments hold in trust, are county governments also entitled to ownership? But there's a case here from Canada which says that because of the great national interest in climate change issues, probably ownership should vest in federal or national authority, ultimately. Then third issue is litigation provoked by environmental approvals, particularly impact assessments, strategic environmental assessments, or audits. And already we have a case from the UK where establishment of a coal project was stopped because climate change issues had not been considered in the decision making. So we should expect, and there is a requirement under the Climate Change Act, that carbon projects should undergo this kind of environmental approvals. Then issue 4 is on participation in carbon markets. Is there free, prior, informed consent? Are there sufficient disclosures in the carbon agreements? And is civil society participation upheld? And there's a lot of domestic jurisprudence, particularly on public participation. But for free, prior, informed consent, there are also international cases we can look at. The 5th issue is, can the ELC determine disputes over carbon pricing and verification? And recently, there was a Court of Appeal decision that appeared to narrow the jurisdiction of the Environment and Land Court in that if a matter substantially does not relate to environment and use of ownership, title of land, then probably that matter should not go to the Environment and Land Court. So there is a possibility that if carbon disputes are framed as commercial transactions, then this will be removed from the jurisdiction of this court, unless we argue that sustainability is at the heart of carbon projects, and therefore this should remain as a matter for this court. There's also concern that not all disputes will end up in court. Actually, the Climate Change Act requires that all carbon agreements, most, should have ADR provisions. So there is a possibility that some of these disputes might just end at ADR level. The sixth issue relates to inequitable sharing of benefits, and this is very problematic because the drafting of the Climate Change Act on this particular matter was not very tidy. The community is not defined, then the composition of the committees is also problematic, and also the benefit sharing is not quite clear. So there might be potential for litigation there. Then lastly, on environmental integrity of carbon projects, do these projects deliver mitigation and adaptation objectives? Do they produce those results? So this is something that is likely to raise concern. Instances where sequestered carbon leaks out, that in itself is a legal risk, and there's a possibility that we might have litigation there. So looking forward, we need to anticipate litigation on those other areas: climate financing, approval of polluting economic projects, the obligation of governments at all levels to adopt climate policies, and lastly, criminal aspects of climate change. Can criminal courts play a preventive role in ensuring that the social pressures piled by climate change or carbon projects do not result in social disorder? So, as I've said, there are novel cases that have emerged in Kenya, particularly around participation. ADR can play a major role in resolution of carbon projects, and to some extent, the alternative justice systems, particularly in the interpretation and enforcement of community benefit sharing agreements. We need to resolve the issue of jurisdiction, and unfortunately, the senator is not here. This is something they probably need to look at. Then we need to build capacity of judicial actors. Yeah, and I think that's it.
Okay.
Sorry for extending, going beyond my time.
Thank you very much for a very well thought out presentation with summarizing of the issues that are likely to arise in the process of climate litigation as it relates to carbon credits, carbon markets, and especially in Kenya, because we now have a fully fledged legal framework on climate change, including the establishment of the carbon markets registry. Now, the next presentation will be by Dr. Maxwell Miawa. I was informed he probably is the only one to travel to Canada to study in Osgood Law School. Thank you very much. You are known, or rumors have it that you keep time. Please confirm those rumors. Okay.
Okay. As she's being sorted, I think it seems that the sub-theme for the three presenters, the first two presenters, revolves or focuses around one thing: climate change litigation, which I may characterize differently as human rights framing of climate climate justice. And I think the question of human rights framing is actually very, very topical in Kenya. It is here with us. As we have seen, there's already litigation around this issue, the Baringo petition, and of late, recently, I must admit that we filed one in Turkana, in Kitale, the Turkana petition, that also challenges environmental violations. So there's a Turkana petition that challenges environmental violations committed by tallow or tullow oil, however you may want to call it, which raises the question of what human rights framing of climate justice is and essentially means. In my view, I think these are the aspects of litigation that implicates human rights in climate change violations or even environmental violations. So I think going forward, because these are new areas, a novel area, what probably we may need to think are quite a number of things. The first of them, of course, would be or a certain point to take home when it comes to human rights framing, going by the already litigation that we have seen and the discussion, theoretical discussions as well. I noticed that there is a marginality, human rights discourse in the environmental justice discourse is still very, very marginal. And I think there need to be more newer nuances in the climate change justice now that it's been recognized that climate justice is really, climate change is really a human rights question. The topic is also very, very new. It's very nuanced. So to most lawyers, to most litigators, like some of us, one of the things that always arises in the newness of this topic are traditional questions. For example, who do you hold accountable? By the way, the question of human rights framing of environmental justice is similar to one of human rights framing of economic justice or development injustices. I do know, because I'm a scholar in the area of law and development, that one of the challenges that we do face is the question of who is to be held accountable, taking into account, for example, that these are not only structural violations, these are institutionally sanctioned violations. One, they are sanctioned by the enabling laws that allows either the exploitation of resources, the foreign direct investment in this country that's caused human rights violations, including in the environmental regime. And that the impact is not to be presently felt. Secondly, there is also a multiplicity of actors, such that if one was to ask the question of causality or chains of causation, as we know it in law, there is a difficulty of tracing who is involved, who is responsible, who is to be held accountable. Other questions that would arise, of course, as I've said, is the fact that how can justice be used to address structural challenges or structural violations, given the fact that climate change, it is not only the state that is involved. And by the way, the human rights language that we do know is a statist language. It is a statist language. I think that's why you still see in the context of the European Court of Human Rights, for an individual to demonstrate local standi, you have to state the direct involvement, what we in Kenya here we call sufficient legal interest. But we do know that there is a big problem with the excessive individualization of human rights, in much the same way that we have a big problem with the excessive, the statalization or statist nature of human rights. So that the question of actors is very, very important and will be very, very important going forward in the future. You can see in the case of a Baringo case, the people that are sued in that particular case is the government, mostly government agencies. But the problem, the tragedy of climate change is not only a government problem. The climate change in Kenya here is not only caused by the state or the state's lack of regulation. It could be caused by other factors, for example, investments or pollution happens all over in the nearby areas. So, of course, we do know that anytime there are new discourses, I think my time is up. I think the other challenge that probably a climate change litigation will face, or the human rights framing of a climate change, is, I can say for certain, is the problem of Anrita Karim Njeru. The problem of Anrita Karim Njeru that still requires, or the strictures or the rigidities of that rule. I know it has been affirmed by the Court of Appeal, but you ask yourself, what if a civil or a social movement, as I call them, moves the court and does not know the requirements of Anrita Karim Njeru and is not able to demonstrate, even the violations, which sits at, I think the principle in Anrita Karim Njeru is actually at variance with Mutunga rules that says that you can file documents, you can even file pleadings by way of a letter. So if a layman files a human rights claim using a letter, how is he or she supposed to know the requirements of Anrita Karim Njeru that requires precision in demonstrating human rights violations? I think that is going to be a great deal of a problem in climate change litigation. As we speak, I can tell you, I can reveal that we are drafting a petition against the IMF, including the government of Kenya. And one of the challenges actually we are facing is that of Anrita Karim Njeru. Because one, as I've said, the violations in the context of development involve structural violations in which there is no individual actor. Causality cannot, causal link cannot be established between the state or any other actor that are involved. Okay? And then I said also, we also realize that the ramifications of economic policies take several years to manifest themselves, such that one cannot discern an actor who is involved. Neither can one even discern the nature of violations. So I think Anrita Karim Njeru, the principle there is going to be rigid. And actually I faced it in one petition that I filed in Kisumu. As I've said, this was a petition filed against a transnational actor, a Chinese company, that caused the violation of the right to a clean and healthy environment. And of course, Mr. Agot, probably Professor Pilo knows him, confronted me with the question of the imprecision in the drafting of a petition. Okay? But I had to contrast that with the requirement in the Mutunga rules and ask, what if it was not Maxwell Miao who brought this petition, who probably does not know how to draft a petition? Will you challenge or throw out a petition that brings out the claims of the right to a clean and healthy environment merely on the basis of not drafting a petition so properly as to identify violations? So the question of evidence, the question of attribution is a very, very critical factor. I've gone through the Baringo petition that was drafted ahead of the Turkana petition, and which I think is the court need to relax the rules, so that in litigation that involves human rights questions, there are those credible reports that always come, either UN reports. Actually, by the Baringo petition is purely based on the UN reports, the USAID reports, UNDP reports, that recognizes that the rise of water levels is actually as a result of climate change. In the petition that we are drafting, and this is a human rights framing of economic justice, or human rights framing of development, we raise the fact that even though we do not have evidence that IMF policies have caused one or the other rights violation in Kenya, but these are credible reports that recognizes that either austerity measures, or in one way or another, or structural adjustment measures that Kenya always adopts annually, have always involved or resulted in human rights violations. Okay? So the question of evidence is going to be a challenge. The question of attribution, or who do you attribute the violations to? And of course, enforcement challenges. There's the justiciability challenges which can be overcome, but then the enforcement challenges. Given, for instance, that, in Kenya here we have what we call a monologic judicialism, as opposed to dialogic judicialism. In the area of climate change litigation, in the context of human rights framing of environmental violations, courts have got to be aware that a monologic fashion or monologues as a way of enforcing judgment does not help. Perhaps structural interdicts are the best. Now, of course, just give me 1 minute so that I touch on the relevant human rights provisions that may influence or inform the in human rights framing of climate justice. We do know that international law is part of our law in Kenya. International law, international rules, international frameworks. We do know, for example, when framing climate justice causes, frame it as a cause, as a social justice cause, as an equity cause, because these are provisions that are found, these are national values that are found in Article 10. The question of sustainable development. And of course, because as I've said, or as had been said before by Professor Kameri Mbote, climate injustices affect mostly the marginalized, the vulnerable. Article 19 makes it a requirement, the duty of the state to preserve the dignity of individuals as a purpose of human rights. Article 21 makes it the state duty to address the needs of the vulnerable, and particularly those who will be most vulnerable and exposed to climate change injustices. The question of appropriate remedies, of course, that's a constitutional question. Climate justice becomes an Article 42 right, as well as an Article 43 right that provides or requires the right to the highest attainable standards of living, because we do know that climate change impacts the quality of life of each and every individual. As well as Articles 162, the court's powers, Article 70 on the remedies. Yeah, maybe I'll address more during the questioning time. Thank you so much. My colleague wasn't able to appear online. Her name is Nina Mwalimu. She contributed to part of the paper that we shared, and I hope she'll be able to answer some questions.
Okay, thank you very much, Dr. Miawa, for well-presented questions relating to developmental injustice in the context of dealing with climate change. And this speaks to what I think the keynote speech was about. We have to be careful in crafting responses to climate. As we try to respond to climate change, we must also be careful in the way we do it so that we don't make people's lives even worse than they are. And I remember Professor Mbote giving examples of greening urban areas and saying that we have to think through so that it's not a question of gentrification. Before we go to the next session, I want to, as a discussant, give very few comments relating or contextualization relating to quotes and climate and environmental justice. The first point is to say that it's there's no dispute or there's no doubt as to the role that the judiciary is starting to play around climate justice, environmental justice, and increasingly courts are being called upon to answer questions or to deal with questions relating to environment and climate change, taking different shapes. I think Professor Mbote mentioned the spike in the number of climate change cases. So judiciary, in the process of interpreting, applying and enforcing environmental laws, of course, will be critical in taking or answering these climate change issues. The grounds, as you can see from various speakers, the grounds upon which climate litigation is being based is widening, coming from a human rights perspective, like Dr. Miawa has talked about, enforcement of climate-related laws. We have litigants seeking to keep fossil fuels on the ground, and I think especially relating to coal, we have seen a few cases emerging from courts where litigants are seeking to reduce extraction of coal as a source of energy. There is a lot of participation, like Dr. Miawa has mentioned, corporate liability and failures to keep or to adapt, either reluctance or lethargy in terms of implementation. And I believe that's the central argument, one of the central arguments in the case relating to Lake Baringo. In other words, the claimants are asking the government, despite being aware of the impact, has not taken enough measures to deal with adaptation. Issues relating to interlinkages, you can see courts will face cases relating to human rights, relating to adaptation, relating to issues brought out and that regard to children. There are issues that are specific to women. There are issues that are specific to local communities, and all these issues are likely to find themselves in courts. So the ability of the court to be able to deal with all these issues emanating from different groups is going to be critical. So each of these groups, the women, the children, the youth, the elderly, future generations, bring unique perspectives and arguments, laying claims of different perspectives, driven by specific vulnerabilities, experiences, indigenous communities. We've already mentioned that. So the court is likely to, will have to, and climate litigation and environmental litigation is challenging the basis of our traditional practice of law, okay? So for instance, I think Dr. Wambua and Professor Gudran already raised issues to do with standing. So if we are to insist that we have to have individualized standing, then we will have, if traditionally we have insisted on individualized standing or local standard for purposes of laying claims in court, then we have to rethink what environment cases would fit in that context, or climate change cases would fit in that context. So we, issues to do with negligence, for instance, will likely come up in court, and the question to ask is whether we will continue thinking of negligence, the tort threshold, as the basis of addressing these issues. So courts, we're seeing a lot of stretching of traditional areas. For instance, I was talking to Professor Goodland yesterday, and there are a lot of issues around trade and the traditional practice and understanding of trade, and what entry of climate change, entry of environmental issues in the trade scenario or in the trade sector would mean. Issues to do with, I think Professor Botte mentioned about refugees, environmental refugees, and climate change refugees. And the question to ask is whether we want to continue insisting on physical persecution as the basis of protecting refugees and asylum seekers. A few comments on the specific provisions. Developmental induced injustices, I think that came out very clearly, and framing them in a human rights perspective. And one of the issues that UNEP, for instance, is dealing with is the issue of just transition. So it's not enough to plant trees. It's not enough to green spaces. We have to ask, where are we greening these spaces? If you have community land, for instance, as a basis where you want to place these projects, there are going to be questions about displacement. There are going to be questions about benefit sharing that Dr. Wambua already mentioned about. I have mentioned about individualization of rights and who is it that to hold accountable. Questions about causation. How do you specifically tie some specific actions around it? We've seen quotes, and I think Professor Gudran mentioned about the either reluctance of governments to act or to act in terms of adaptation in itself is becoming a basis for holding governments accountable. Finally, on the carbon credits, I think fortunately I have participated in drafting a few of carbon markets legislations in Africa. And one of the questions, we're still running that project, one of the issues has been the conceptualization of carbon markets and the carbon credits system. It's itself based on, for instance, property rights and property systems, okay? So if it is developed in a certain context where we insist on private rights, we have to contend with issues around community land. For instance, if Professor Botte was here, will tell you the largest part of land in Kenya is community land. So issues to do with benefit sharing, issues to do with who benefits, do we conduct economic, social and economic aspects as we do these carbon markets or carbon credit. And the framing, and this relates to the jurisdiction of ELC, how do we frame carbon market, is it a purely commercial transaction? Does it have human rights? And does that mean that when I am laying a claim on carbon markets or a carbon project in a human rights context, then I am able to approach the court? But if I frame it as a purely transactional or commercial dispute, then it goes to the civil court. And these issues will keep coming up. And one of the issues to mention there is the interlinkages. So one project would have human rights issues, will have participatory issues, will have commercial issues, will have imbalance of power, will have government involved, we have indigenous rights, and trying to demarcate all these issues, it's an issue going to appear before the court. And finally, I think Dr. Wambua mentioned the issue of carbon credits itself, double accounting, for instance, the transparency and the accountability of that mechanisms under Article 6.2 and 6.4 of the Paris Agreement is going to be an issue. With that, I will want to ask the floor if they have two questions. I mean, we'll have questions. Please direct your questions to a specific person. I don't want to leave this session because the next one is on a completely different topic, and I wanted us to exhaust the issue of courts, climate change, and disputes around it.
I have two questions. I think for the three, any one of you can. Yeah. All right, it's just one. I'll just go with one. The issue of enforcement of judicial decisions in climate litigation. For example, the Uhuru Wino case, you find that the government has been ordered by the court to compensate the victims, and at the end, the victims never get that amount. What is the way forward? And how do you deal with a foreign pollutant or an MNC who is taken to court, and then when the case is ongoing in court, they close shop and they go?
Thank you.
How do you do that case?
Thank you. Would you like to direct the questions to, and please state your name?
The name is Oganga, and I give it to any of them.
Okay, thank you. We'll know who to assign. A next question? Please state your name, one question, and who you are directing it to.
Good afternoon. My name is Samuel. I'm directing my question to Dr. Wambua, and probably around the issue of carbon markets and the transactional nature of the corruption involved. And maybe I'm just thinking around a suggestion by the NEMA on the register, to have a register. Do you think that would help? Is it akin to the conversation we usually have here around beneficial ownership? Would it help, or would it be a step in the right direction? Thank you.
Okay. I will direct Dr. Miawa, and Professor Gudran can answer Shem's questions, however you choose to. Then Samuel's question will be addressed by Dr. Wambua.
The Unwritten Karim is a judicial decision in Kenya. Is a high court decision, and its basic principle is this: that if you bring a claim before the high court alleging that your rights have been violated, you must do so with the highest level of clarity, precision, in such a way that you are able to identify those violations and the provisions of the law that have been violated, and how those rights have been violated. And that poses a dilemma in Kenya. And of course, that decision has been affirmed by Mumu Matemu, affirmed by the Court of Appeal in the case of Mumu Matemu versus Transit Society. That brings a problem in Kenya in this way, that we do know that the increasing human rights framing of either economic justice, environmental justice, climate justice, is done by people who are non-lawyers. Okay? In fact, some of the constitutional challenges against the government have succeeded, not because they've been found by lawyers, but by non-lawyers. There is also a contradiction, or that the principle in Ankarimi Nyeru contradicts what we call in Kenya Mutunga rules. So these are rules made by the Chief Justice for purposes of enforcement of fundamental rights. And they were intended, because there's a history to enforcement of fundamental rights in Kenya. There's a history whereby the chief, one of the judges would just say, there are no rules, so I cannot even listen to you, even though you have brought a case before me, and the cases will be thrown out. The Mutunga rules had the intention of making it clear that even somebody who walks from his house and approaches court by way of a letter should be heard, and that it is the duty of the court to identify those violations, the provisions of the law that are being violated. So I think going forward, given, for instance, that most of the litigation cases will be brought by social movements who are not necessarily lawyers, will we throw out these cases? In fact, yesterday, housing levy fund was thrown out on one of those grounds was that the petitioners were not able to identify the violations. It is the duty of the court. In fact, the post-2010 constitution refocuses that duty and places on the court that it is your now duty to define and identify where those violations are. Okay? Yeah. Enforcement of court orders is still a problem. That's why we need really move away from, and of course the courts are already moving away from, the history, the tradition whereby court pronounces judgments. Once a court's judgment has been pronounced, the court becomes functus officio. The doctrine of functus officio has been displaced in this country, such that courts should now focus on crafting appropriate remedies. And appropriate remedies is not, the language appropriate is not limited in the Constitution. So courts can start implementing, supervising their orders. Okay, so judges should know that awarding compensation will not help. You can give a monitoring period of, let's say, 90 days, 3 months, come back before me and show progress, so that if the government alleges we have no budgetary allocation, then the institution responsible should demonstrate in what way, what steps, what measures are they taking to ensure that these people are paid even in the next budget cycle. By the way, in Colombia, courts, the highest court has been supervising cases involving human rights for over a period of 10 years. That's why I insist that the doctrine of functus officio is actually displaced and misplaced in our context.
Thank you very much. As the mic goes to Professor Goodland, I think the question Wambua is to handle, Dr. Wambua, is relating to carbon markets. Okay, and it's to basically state, for instance, and before Dr. Wambua comes in, is the hallmark of carbon markets is based on, one, accessing climate finance, that's one. Secondly, it is based on the idea of transparency. And I think the idea is you do not want to have countries that can trade in carbon credits, whereas they have a similar, an equivalent obligations around nationally determined contributions. And the double accounting problem would come in where you sell credits in the sense that they should be credited into another country, but you are using the same basis to say that you have complied with your national determined contributions. So the issue of transparency, issues of registry, as Dr. Wambua responds to that, I thought that is important to mention. Please, Professor Goodman.
Thank you very much. So I think the question is about enforcement on the international level, human rights level. So we know in public international law, enforcement is always kind of problematic. International law works because states commit in good faith and try to implement their obligations. So in human rights law, the European Court of Human Rights is kind of special or outstanding. As I said before, it can tell the state you violated the human rights of an individual, you have to take these and these measures, or you have to bring your national legal situation in compliance with our decision, and it can award damages. Yeah, and this is kind of extraordinary, and this happens. All this is monitored by all the member states in the Council of Ministers, and Switzerland will have to report every 6 months what they have done. Of course, changing the legal framework takes time, but this is, I think, the most effective tool we find in international human rights law. And another effect beyond that is, of course, that all Council of Europe member states, so all the other 45, are checking their national legal systems to see whether the climate measures meet these criteria the court set up, because we can be very sure that in all the countries we have several NGOs now starting to preparing complaints, and that's what states fear. You never want to be drawn to the international sphere, basically, and be pointed at you. And I can tell you, I met people from the foreign ministry, Swiss foreign ministry. They were so upset about this judgment and felt so ashamed about it. Okay, I think.
Thank you very much. If you could pass the mic to Dr. Ambwa.
Okay, thank you. Just to add on to the responses on compensation, I think the requirements for carbon investors to deposit environmental protection bonds, I think that could also add a layer of protection of communities in case of the need to compensate them. I mean, the bonds can be confiscated and remediation done. So maybe that's an extra regulatory safeguard in relation to that. Now, on the question of integrity risks, transparency, corruption around carbon markets, of course, the contracting process needs to be clear, simple, and the people need to understand. Personally, I'm involved in a carbon credit project as an individual. I've signed on to it, and I didn't know until I saw the agreement and read it. In the fine print, I was required to transfer any claim to any carbon project that will be realized from what I was purchasing. And I was purchasing a biogas system for my rural home. So, so unless we sensitize communities to read through those agreements, interrogate them, yeah, you just sign off your claim to your carbon rights without knowing. So that's one thing we insist on. And to help this, we could insist on having in our carbon regulations model contracts, yeah, so that even the investors have a template that they can follow. There's been prescriptions on how these agreements can be done, but I think we need to go a step further and provide for those model contracts. Secondly is on beneficial ownership. I think our jurisdiction now tackles this properly under the Business Registration Service Act, if I'm not wrong, and also Companies Act. But of course, communities need to be vigilant. In the last 1.5 years, there's been a frenzy of land transactions, particularly in those marginal areas where projects, sequestration projects are being implemented, targeting rangelands. So the rich are busy buying those properties, which hitherto are community land. So there's need also for vigilance to see who's buying this. Are they buying them fairly? Are they compensating the communities fairly? And you'll be surprised. Our political actors are quite involved in that. But there's a framework to deal with that. Then on double counting, good thing is that the Paris Agreement has tried to address that by even requiring carbon credits generated in the voluntary market should also be accounted for as part of countries' national determined contributions. So in a sense, that will force the voluntary market into the regulated market fold, because once you disclose, then that means you also bring yourself into the regulatory fold of the regulated market. But then the establishment of carbon registries at the national level linked to the international carbon registry, I think that's also a positive thing. We will just need to make sure that the disclosure safeguards in our carbon markets law and regulations will be applied. If anybody needs to get any information from that registry, it should be unfettered access to that information. With that, I hope. Then the last thing, locus. I think our progressive locus standby provisions will also aid in mitigating some of the integrity risks. If somebody feels that a carbon project has not been properly mounted, you can go to court. And I'm surprised, how come our locus standby provisions are so liberal as opposed to the European provisions? I had opportunity to study Swedish law, and I was equally surprised. They have a very restrictive locus standi regime. So what explains that? We borrowed most of our norms from Europe. Why are we ahead of them on that particular instance? Thank you.
Okay, thank you very much. I think it's a very good place to close the session. Just to note that we have, at the international level, we have recently gotten the advisory opinion from the United Nations Tribunal on Law of the Sea. It's good that if you look at it, it's the first international, at the international level, to deal with the issue of what is the state's obligations as relates to climate change. There is another one coming up. This one was an advisory opinion requested by United Nations General Assembly before the ICJ, and I know the hearing is going on. So keep track of those two, hopefully, and the regional courts as well, to see what's coming up. Thank you very much. Please assist me in clapping for that group of presenters. I will quickly move to the next presenter, who deals with still the issue of carbon credit, green tax, and financial transactions around it. Mr. Simon, you have strictly 7 minutes. I may appear to be very generous, but that's appearance. Thank you. Please welcome him.
Okay, thank you so much. Now, from my side, I'm looking at, or we are looking at, with Professor Beatrice, we are looking at climate justice from the lens of green taxes as a means of redistribution. Now, here we are going to look at, Professor Botes talked about corruption. We're also considering the effect of corruption in this relationship, but our area is on how these green taxes are going to affect corporate performance. Now, as you have seen from the topic, that is slide number 1. So we are looking at green taxes and commercial banks' profitability. And we sampled, or we looked at data from developing countries. And the reason for that, as I'm going to explain, is because for them, mostly they don't have strong legal structure. So anyway, we can start with the introduction. And as our professor has said, we need to start with the definition. When we look at green taxes, we refer to all those levies that are going to be charged for anything that is going to harm the environment. And the main aim is to promote sustainability. But then, when we look at banks, banks are not going to be directly affected by these green taxes. And the main reason is because they have raw harm. They produce raw greenhouses, mainly because of their computers. But most of the time, you find that it's corporates that are going to be affected. But now, banks come in the form of, banks are the main sources of finance for farms. So what would happen is this. From a theoretical perspective, is that when taxes are charged, or when these green taxes are charged, we'd expect that one issue is that there are going to be increased expenses. So with increased expenses, banks are going to suffer in the form of that they cannot be able to, or they are not going to attract, firms are not going to borrow. And with low borrowing, their profitability is going to be affected. But on the other side is that the aim is that green taxes are meant to drive innovation. And with innovation, we expect that firms are going to get new sources of income. They are going to be competitive. And being competitive, they are going to be able to repay their loans. And with that, bank profitability is going to be enhanced. You can go to the next one. Now, but another thing that comes up is this. According to FUA and GIAN 2021, is that for green taxes to enhance innovation, there's a requirement for a strong regulatory environment. But when you look in a weak institutional environment, a common characteristic in developing countries is that firms may not actually pay these green taxes, but they may leverage or go to bribe, bribe tax authorities, and in doing so, they'll be able to evade the burden of paying taxes, and at the end, they are going to enhance their performance. So this is what we call the grease the wheel effect. But on the other hand, is that corruption can also add extra expenses to firms, and also create uncertainty in the form of that. If you're able to bribe, you're not going to invest in this green innovation. And if you are not going to invest in green in sustainability measures, you're going to pay these taxes. And with that, your expenses are going to increase, and you won't be able to pay your loans. And at the end of the day, banks' profitability is going to reduce. So when we looked at the literature, we realized that empirical evidence did not provide any, or there were no studies, particularly in developing countries, on how green taxes affect bank profitability, and also the role of corruption in that relationship. So the reason why we did the study, or the main aim of our study, was to look at the impact of green taxes and on profitability, and how corruption influences this relationship. So our methods, so we sampled about 2,348 commercial banks from 103 developing countries, and these countries were from Africa, Latin America, and Asia, and some few countries from Eastern Europe. Then, because we are trying to look at how this side, the dependent side, that is our profitability, and on this side, the controls and green tax. So we are looking, it's going to influence the profitability. And how we measured profitability, we use two measures: return on asset, that is net profit divided by the assets of a bank, and secondary return on equity, that is net profit divided by equity. Then green taxes, we measured green taxes as the ratio of environmental taxes over GDP. Then, because we used two methods, first of all, we used ordinary least squares, then we used the fixed effects model. And for a fixed effect model, the reason why we employed this method is to control for an observed heterogeneity, whereby, for instance, the data that we are collecting here, you can see that we looked at those control variables that have been identified in previous literature to influence performance. But there are other things that we did not consider. For instance, management efficiency or the culture of an organization. We did not measure that. So that is the reason why we decided to employ fixed effects. Secondary, two errors, two-stage least squares, because of reverse causality, whereby profit of a bank can influence green taxes. And this is the form of that. Banks may make profits, and the government decides that we are going to implement green taxes as a means of correcting additional taxes. So we use the two SRS to control for that. But the main reason why we have these three methods is for us to see whether we are going to get consistent results. So this was just how we measured our variables, starting with profitability, as I have said, lower and ROI. Then we had taxes on pollution, which we measured as a ratio of country taxes on pollution to gross domestic product. Then the NG gain index and the level of engagement, we use those two as instruments for the two-stage risk squares. So our argument for ND gain index is that this index shows the vulnerability of a country to climate change. So if a country is more vulnerable to climate change, we expect that it is going to implement green taxes. Secondly, if a country is engaged in environmental agreement, we expect that it's going to implement environmental, these green taxes. So I'm going to give them, you can just give me 3, 4, 5 minutes, I'll be done. So
5 minutes is 2 minutes.
Just read.
Your time starts now.
Okay, yeah, 3 minutes. So anyway, these were our results after we did our regression analysis, and you can see So first, because our main interest is taxes on pollution, you can see that we had a consistently negative effect of taxes on pollution on profitability. And our argument is that the taxes increased expenses for farms, and with increased expenses, lower on demand and lower profitability for banks. Second one is when we included corruption in the relationship. And you can see that where we have the corruption variable and green taxes, the relationship tends to change to positive, meaning that with low levels of corruption, green taxes are going to enhance profitability. And the argument here is that if we control for corruption, firms, number one, are going to invest in, they are going to innovate and get these extra sources of income. It is also going to create certainty that if you invest in green taxes, you can get returns from that. Then the other last two tables, we try to do some additional analysis where we considered countries that have low greenhouse emissions with higher greenhouse emissions. And just a brief, for countries with low greenhouse emissions, you can see that taxes on pollution had a consistently negative and significant. Then when we add corruption in the relationship turns to be positive, meaning that in countries with low greenhouse emissions, they are able to control corruption, and that is the reason why we have this positive relationship. But on this side, it's totally insignificant, meaning that these countries probably rely on, one thing that is going to happen here on this side is that these countries rely on fossil fuels, such that even if you control for corruption, nothing is going to happen. So just last part is that from what we did, our results, so we had this implication from our study that number one, there's need to balance sustainability and profitability, and that is by providing subsidies and tax incentives. And that was because of the negative relationship between green taxes and profitability. Second one is the need to address corruption, as Professor Botte said. And lastly was banks need to finance green investment, especially in countries with low corruption and low greenhouse emissions. Thank you so much for that.
Thank you very much. And interesting perspectives on corruption, profitability, financing, and dealing with climate change. Now, you will allow me to move very quickly to the next group of presenters. Samuel and Andrew, and this relates to land rights and climate change. I will come back and give a few comments, and we close that session. 7 minutes.
Thank you, and good afternoon. I'll be very brief because part of this conversation, I think we have had it all day through. It's intertwined, and for us in this conversation, we are looking at climate change and land rights, and how climate change affects enjoyment of land rights. And for this, we are looking at having climate change having a very wide spread effect on human land use and occupation, including how we access land, tenure, and also livelihood, how the different effects of climate change that we have interacted with since morning, including drought. We have mentioned something to do with climate change in terms of maybe temperatures. We also have deforestation. All this has an impact on how we use land, and I'm very sure most of us have interacted with, and so have our brothers and sisters from the different setup. Going forward, we also have land corruption and how it's affecting the connection between land corruption and the climate change conversation. And now we are saying there is so much around corruption. I think the conversation, even from the previous presenters, we have mentioned about around governance and corruption and how it's affecting the conversation on climate change. We are saying in an ideal situation, secure land tenure is essential for climate adaptation, enabling communities to invest in sustainable practices and protect their livelihood. This morning we were told it's very hard to protect or even invest in a system that you do not own or have control over. So when you are not assured of your land rights or even security of tenure for your land. It becomes so hard to even adopt some of these climate strategies, climate resilience strategies. It becomes so hard to do that. And so for this paper, we are trying to highlight impacts of land corruption on climate action and challenges that are there. And we have a number of questions. Key among them is, how does climate change affect land use? And we are saying this is connected in a big way. I've said the effects that we mentioned this morning and how it's affecting land use. Part of this conversation revolves around the wetland conversation that was mentioned in the morning, how we are being pushed away from areas that we have inhabited because of climate change, how we are not supposed to be there, how some of the system or even the people in power or even ourselves are taking advantage of the situation and doing a number of practices that are leading to this. And so from it, we have a number of challenges. I think our main focus is on the challenges and also some of the recommendations. And one of the challenges we are speaking about is land corruption and land grabbing. We are all privy to a very good example of what is happening in Mau Forest. People are being pushed out of it to create way for government projects, and also we have people at a personal level who have grabbed land. And for this, the same story continues. Bribery, we have fraud, we have illegal dealings within the ministry as part of how the corruption is manifesting itself, but also how it's affecting people living within Mau Forest, and so many other examples we have given in the paper. And I think I've also mentioned how this is weakening the ability of communities to adapt to climate change. If you can't even get the basic of things from enjoying your land rights within the small space you have, then it becomes so hard for you to think about the bigger conversation around climate change and climate resilience. So that is the conversation. Then we have also that insecure land tenure for the communities that are most vulnerable. We are saying the most vulnerable are also the most hit by this. Before it gets to the middle class and the rich, it first hits the most vulnerable. Example, the pastoralists who have to move away or even adopt to different strategies to ensure they get their livelihood. Another challenge is the weak implementation of legal and policy frameworks. We have a very progressive laws or constitution, the main anchor, but still we still have that challenge of implementation of these laws and also having them integrated into the policy and all that. Then we have the other one, I'll be very fast, impact of large-scale land acquisition. A good example is the Mau that I've stated that continues to displace people, and even the carbon conversation that we are having that is leading to environmental degradation, where people continue to have land grabbing. The other challenge is marginalization of indigenous people, leading to conflicts. Again, we go back to that conversation of the most vulnerable being the most hit. Gender inequality in land rights, I think also women and the youth are hit by these impacts most. One of the presenters this morning alluded to that fact on how this is impacting on their livelihood as the people who are most vulnerable. The last one is on the recommendation, and we are saying we need to highlight the critical need for stronger governance enforcement. Just a minute, should be done in a minute or so. We need to strengthen or have strong governance enforcement of anti-corruption measures and inclusive land reforms to support Kenya's climate resilience and secure land rights. And so allow me to just mention in passing some of the recommendations that we are projecting. They need to have to strengthen land rights and tenure security. I've mentioned that. We need to have legal reforms around that and also empower the institutions that have been put into place. We need to be very deliberate in combating land corruption. At this time and age, we still have people who are grabbing even public land belonging to public schools. Leave alone the setup that we have seen in Naivasha and other areas, then mainstreaming of anti-corruption in climate and land sector, including the policies and also the oversight institutions that have been put in place, then enhancing institutional capacity for that governance to be able to undertake their mandate as required. Lastly is tackling large-scale acquisition, including the projects that we are implementing, most of which are good, but some of the people that we have are taking care of that. Lastly is in empowering women in land rights and climate action to be able to also come out and protect the space that they are in and also get more access to information and being vote more. Thank you.
Thank you. Thank you very much. As we get set up online, can I ask Jane and Muriuki to come? And as they come, I think the question the presenter was raising, if, for instance, we insist on title, people formally written or who owns land on title documents, who we know they are not, majority of them are not women. If we insist on contracting based on who owns land that carbon markets or carbon projects are to be situated in, as around land rights, then who would be responsible? Okay. Next. As the presenter takes, please, Dr. Ogedi and Evans Ogada, I know you are online. Please prepare in the next 5 minutes. Muriuki has promised me to be very brief.
Yeah, certainly. I'll be quite brief. We're presenting with Jeanette the paper. So mine is to basically introduce. We are presenting on land rights in the context of climate change. So essentially is looking at how climate change impacts on property rights or land rights. Both land tenure, I think it overlaps a bit with the presenter was here, how it impacts on land rights or property rights. So obviously there are interlinkages between property rights and climate change, which is obviously important for policymakers when they are designing both climate policy and land policy. So I'll welcome Jeanette to come and give the insights.
Okay, thank you. I'll quickly go to the linkages that we found between land rights and climate change. So the first thing that we looked at was how the rise in sea level as a result of the melting glacier caps has affected land rights. So first of all, of course, it causes landlessness. So we looked at, there's this village in Tana River County where we found that in less than 7 years, approximately 2.5 acres of land have been swallowed by the sea. It also causes displacement of people and conflict over resources. So right here in Kedong and even Laikipia, there are conflicts between pastoralists and existing communities because they've had to move due to climate-induced changes. There's also natural resource-based livelihoods are affected. And there's also increased migration from coastal areas to other urban and rural areas, which of course causes greater land competition and inefficient use of resources. So something else that we looked at was how the climate adaptation and mitigation measures affect the right to own, use, and access land. So some of the efforts which Samuel talked about, they're implemented at a large scale. So they lead to compulsory acquisition of communal land or private land. And so the primary users of this land, whether it's farmers, pastoralists, or indigenous people, they're denied access to the land. they're denied access to these resources that they need to sustain their livelihoods and even their cultural identities. There's also the fear of eviction, which creates uncertainty in land tenure. Samuel talked in detail about this, so I'll just go to something else. There was also the carbon credits mechanism, which was designed to reduce greenhouse gas emissions, but this could also affect land rights because these projects, they impose land use restrictions on the land that is sequestering carbon. So these restrictions may include activities like no logging or farming or hunting, and this will now undermine the livelihoods and practices of the local communities who rely on these activities for subsistence and cultural expression. So also encouraging conservation measures that deal with climate change may also prioritize certain land use at the expense of existing land uses. So for instance, may encourage conservation or afforestation in place of agriculture, which is the main resource, the main use of land. So based on the above and more points, we're just rushing through because of time. Some of the recommendations that we made were inclusive policy development, where we engage local communities, especially indigenous people, in designing and development of climate and land policies. This is because their knowledge and experiences are vital for developing effective and equitable solutions. We also had community-based adaptation, where we support initiatives that allow communities to implement their own adaptation strategies. So also integrating traditional knowledge, where we recognize and incorporate traditional ecological knowledge into climate adaptation and mitigation strategies. This will enhance biodiversity and resilience, while also respecting cultural heritage. The last point will be education and awareness. So just raising awareness about the importance of land rights in the context of climate change among policymakers, communities, and stakeholders. So this will foster a greater understanding and cooperation. Yeah, I believe that's it. Thank you.
Thank you very much. I have 3 points to make with relating to land, and then I have Evans Oganda, please prepare, and Dr. Okedi, you will be the last 2 presenters. We will take questions and interventions thereafter. I think the presenters have touched on the issue of security of tenure. We already have very insecure tenure systems, and adding climate change into the whole scenario again makes the situation worse. So addressing tenure systems is critical into dealing with climate adaptation. And we might have to do some adjustments, just like I asked, whether if we insist on having people who are formally recognized on title deeds, for instance, to be the beneficiaries, and contracting people in carbon projects, then we would be excluding a huge chunk of the population, in this case, women. We've also seen a contestation between 2 tenure systems, especially when there is drought. You are familiar with the Laikipia cases around ranches. It's one land tenure system, that is communal land tenure system, and private land tenure system in the context of climate change. Then it brings in a contestation between the 2. Then there is a human rights approach to all these, which I think leads to what Professor Mbote mentioned in the morning, environmental rule of law, in the sense that we stop seeing environmental issues, climate change issues as merely others, and insist that if there is environmental pollution, if there is corruption in the land sector, it is a fundamental problem of rule of law problem in that country, and it doesn't speak to environmental inadequacy or lack of enforcement. It generally speaks to a bigger problem, a bigger governance problem called rule of law problem in that country. If I could have Evans Oganda, please. If you can hear me, please proceed.
Evans is here. Good evening. Can I be enabled to share my slide presentation?
We'll work on that.
just a minute.
Thank you very much. My apologies. I was meant to be there physically. Unfortunately, due to some exigencies, I'm not able to attend physically today, but good to be here. Thank you, and thank you, Egerton, for this opportunity. Now, my presentation will be on cultural norms and climate change in Africa. The African continent, in its rich cultural diversity, has had long grappled with the challenges posed by climate change. So while the impacts of climate change are increasingly evident, the continent's cultural norms offer a unique perspective on environmental stewardship and resilience. So my presentation today will be to explore the intricate relationship between
Evans,
African cultures.
My apologies, you are now able to share your slides.
Thank you. So saying that my presentation today will be on the intricate relationship between African cultural norms and climate change, highlighting how traditional practices and beliefs can contribute to effective climate change mitigation and adaptation. Through case studies from a number of African countries, we will see that the potential of African cultural norms are as a powerful tool in addressing environmental crisis. Now, historical environmental knowledge is there in Africa and has been part of the African cultural setup. This knowledge, this understanding was often transmitted orally, and it includes information on seasonal climate change, seasonal climate patterns, biodiversity, and ecosystems. Community-based resource management. Many African cultures developed systems on communal ownership and management of natural resources, ensuring equitable distribution and sustainable use. The respect for ancestors and the natural world, our belief in ancestral spirits and the interconnectedness between these spirits and the living had created reverence for nature. This spiritual connection encouraged sustainable practices and discouraged actions that could harm the environment. Intergenerational equity. African cultures often prioritize the need for future generations, emphasizing the importance of preserving natural resources for posterity. Traditional ecological knowledge, TEK. TEK, traditional ecological knowledge, was passed through generations, embodying a wealth of knowledge about local ecosystems and the interactions. This knowledge that has been passed down to us can inform climate change adaptation strategies and promote sustainable practices. Now, many pastoralist and agrarian societies in Africa have managed natural resources through community-based systems, which include, for example, water management systems, where community managed wells, rainwater harvesting, and river diversion inform how we deal with water management, for example. Soil conservation techniques. We had terracing, crop rotation, intercropping, forest management. Some communities, including the Ogiek in the county you are in currently, practice sustainable harvesting and replanting systems that maintain forest health. Climate adaptation strategies, agroforestry, diverse cropping systems, livestock management, where pastoralist communities observe traditional herding routes and practices like seasonal migration to help avoid overgrazing and allow pastures to recover. Now, because of the shortness of time, I want to go quickly through the cultural norms that have been practiced in Africa in terms of climate change by way of illustrations. So, for example, the Maasai pastoralism and Maasai practices. Maasai pastoralists have developed sustainable grazing practices that have allowed them to coexist with the environment for centuries. The understanding of seasonal patterns, land degradation, and livestock management has enabled them to adapt to changing climate conditions. Ghana, sacred groves have been protected, and these sacred groves are associated with spiritual beliefs, and this plays a crucial role in conserving biodiversity and regulating ecosystems. In South Africa, indigenous communities in South Africa have developed traditional forest management practices to promote their biodiversity and conservation and sustainable resource use. The Turkana in Kenya, their traditional fishing techniques have been adapted, to the fluctuating levels of Lake Turkana. My brother, my good friend, Dr. Miyawa, this is something that will interest you with your petition. Farmers in Burkina Faso using the traditional Zai pits for water retention and reclaiming arid land. Ladies and gentlemen, owing to time, what are the challenges that we face in the context of climate change that will impact on TK, traditional knowledge and traditional methods? Access to climate change information is a problem within African societies. Marginalization of indigenous communities, which means limited access and exclusion from decision making. We also have the challenge of conflict with modern scientific approaches, scientific dominance, intellectual property rights. These work to the disadvantage of traditional knowledge and traditional methods of curbing climate change. The impact of climate change on local ecosystems, we have unpredictable weather patterns. These make it difficult for traditional knowledge to be impactful. The loss of biodiversity, this is a problem for traditional knowledge to be impactful. In conclusion, strengthening indigenous knowledge in climate change adoption is imperative. Despite the challenges that I have quickly gone through, there is growing recognition of the importance of indigenous knowledge in climate resistance. Indigenous communities have shown us an ability to adapt their knowledge systems in response to environmental changes. Collaborative efforts between scientists, government, and indigenous communities are vital to integrating traditional knowledge with scientific data, allowing for more holistic and effective approaches to addressing climate change. Addressing the challenges to indigenous knowledge in the context of climate change requires a multifaceted approach, including stronger legal protections for indigenous rights, the inclusion of indigenous voices in policy making, and efforts to bridge the gap between scientific and traditional knowledge. Empowering indigenous communities to lead adaptation efforts can result in more sustainable and culturally relevant solutions to the challenges posed by climate change. Ladies and gentlemen, thank you very much.
Thank you very much, Ogada. If you could please remain online, just in case there are any questions. Dr. Ogedi, please, you may proceed. You have rights to share, so you can, thank you. Please proceed, you have 7 minutes. Thank you.
Okay, you see my presentation? Are you able to see my presentation?
On my end, yes, Paul.
Okay.
Yes.
So I'm going to discuss with you a topic which is very interesting and current. It is on the artificial intelligence. And what I want to do is to try and link it to the climate change problem, that we can leverage on AI to address some of the issues that we are facing in the climate change. I'm sorry I can't be able to move my presentation. I don't know whether I can see it. Okay, so I will not use the, I will not share because I can't move it from my side. I don't know what is the problem. So number one, we know that AI is the fourth industrial revolution. When we say about fourth, we mean that steam engine, electricity, and the internet revolutionized the way industries were performing and in terms of production and everything else. So now AI is currently being adopted and deployed in virtually all sectors. So if you look at the healthcare, education, transport, and energy sectors, you'll be able to see how these sectors are deploying the use of AI. One of the areas that I think this particular approach or move should also extend to is in climate change, or the area of environment. Now, what are the challenges of climate change? We need, when you're thinking about artificial intelligence, to deploy or to come up with new innovative production systems that will target reducing emissions. Now, the AI can be used as a tool for this particular purpose and therefore help in combating climate change. So there are 5 areas that I will look at. One of them is clean energy solutions. The other one is the eco-friendly food production system. And then carbon sink technologies, pollution monitoring and prevention technologies, and then lastly, illegal logging detection. So all of these are relevant in combating climate change. And how is it that it has been used in the past or currently as we speak? So the first one is clean energy solution. So the target here is to be able to reduce to low or to zero emission, or maybe put differently, to have energy efficient options. So if you look at what Elon Musk, for example, is doing with Tesla, it is about having zero emission in terms of motor vehicle. What are the benefits? It will save you cost. It will also reduce carbon emissions, job creation, and enhance energy security. Now, if you look at the US, we have a very good example of why they're moving towards clean energy solution through using the law. And the law that we are going to discuss here is that there is funding being allocated under the US bipartisan infrastructure law to support sustainable transport initiatives. Under this particular funding, the US Department of Energy's or Energy Efficiency and Renewable Energy supports sustainable transport and freight shipping infrastructure, including vehicle charging capabilities, urban and community design, and road and bridges. So all this particular funding is supposed to make sure that when this technology is deployed, then it is able to work. And that is why you find the government even investing in vehicle charging capability. So the second part, and I'll be moving very fast because of time, is the eco-friendly food production. Here we can learn from what we have known in Israel, that they have been developing meat. One of the criticisms in agriculture or animal agriculture has been that it has been the biggest contributor, if not one of the biggest contributors of emission of CO2, which bring about warming, global warming. So one of the ways to combat this is to look at alternative ways of having the same product developed. So here you cultivate meat and what it does, and one of the farms that has been able to do this is Aleph Farms, Super Meat and Believer Meats. According to Israel, they are aware of the acute limitations that exist in animal agriculture, and therefore it is promoting alternative proteins as an economic growth engine, a technology to mitigate the climate crisis, and as a food security asset. So this is happening as we speak. In California as well, we have even the creation or growing in laboratory of the chicken. So there is even in 2022 an FDA approved cultivated chicken in this regard. So if you are able to avoid live animals and we move on to biotechnology, we'll be able to have part of the problem, which is emission of green gas, sorted out. The third area where AI has been deployed is carbon sink technologies. And here we are talking about sequestration of carbon. And one of the things that can be done is we can deploy AI or automate it in monitoring and evaluation of project performance. So imagine, for example, you are planting trees on a large tract of land. AI can be used to analyze real-time data from sensors on the trees to identify any deviations from expected performance. So for example, if it detects soil moisture levels lower than expected, it can alert the developer to possibility of drought stress, allowing the developer to take action and address the issues more quickly. So you can see how this AI can promote carbon sink by simply just alerting the people who are planting trees or who are managing forests to be able to take remedial measures when it is required and in good time. The other thing is monitoring pollution. And here you can do it both in air and water. So in Southeast Asia, we have the Survey Air Quality Tool, which uses AI to help government and regional organizations, such as the Association of Southeast Asia Nations, to accurately predict air pollution levels 3 days in advance and take actions to reduce risk to human and environmental health. So this is just a very important tool that government can use to just make sure that air pollution does not affect human and environmental health. Lastly, one of the AI functions is also to detect illegal logging. And here we have the example of World Wildlife Fund through forest foresight, a new intelligence system is able to detect illegal logging. So institutions such as Wageningen University are working towards even smarter systems which have been tested in Gabon and are proved promising in detecting illegal logging. So deforestation is has diverse impact on climate change, and the lack of adequate forest monitoring contribute to this. Through the use of AI, satellite technologies can be used to ensure that there is clear, accurate, consistent spatial data on deforestation. So one of the technologies being developed is the Earth-friendly AI, which has been touted to be a way to enhance data collection methods. What can we do? Therefore, my recommendations is that there's need to focus on coming up with a climate AI framework, and this is supposed to be a mosaic of innovative solutions. So apart from other things that is happening, AI sits at the center of that mosaic and is already contributing to massively increased transparency, faster gains in efficient power generation and storage, and renewed confidence in large-scale investments and other things. Now, AI cannot be used to solve the climate crisis in isolation. So the decision makers must be there to support AI partly and also other emerging technologies to work AI technologies. How about the Kenyan government? We need the Kenyan government to take up AI seriously and devote targeted resources for the responsible adoption of AI for climate change solutions. So the government can work on digital infrastructure in order to ensure that the incentives in the relevant industries are aligned with climate-focused innovation. And I think you saw the example of the US funding on AI infrastructure, including charging. The government can also work towards closing the capacity building gap on AI and climate change by empowering businesses, communities, and individuals with knowledge, tools, and recruiter skills required for adoption of AI. So this is about education, and we can have prioritizing funding for AI climate projects. Lastly, the government can also establish and implement standards and best practices that are able to be used in this particular process of incorporating or using AI to combat climate change. Thank you very much.
Thank you. Please, some appreciation. Thank you very much, Dr. Ogedi, for a good presentation. I have 3 points to make, and then I will invite questions for the panel that have been speaking, and then we will close it there. I know we are 7 minutes late to when we were supposed to close, so we are still within the African time. I hope I can borrow some other 10 minutes. Now, taking it up from where Dr. Ogedi has left now, science has probably been the most influencing factor in climate change negotiations, climate change policy making. And we can also see science leading in planning, leading in taking responses. In this case, Dr. Ogedi mentions about AI. And I know in the Summit of the Future, which was, I think, in September, the issue of AI was raised or came up in the General Assembly, and I think we'll start seeing a lot of work around it. Regarding in the access to justice context, science is an influencing factor. There has been an issue, and I think one of the presenters will be dealing with it tomorrow, the issue of access. And the issue has been that most of these technologies, including the AI, are located in, for instance, developed countries. So the vulnerable communities in the global south, the vulnerable communities in developing countries have a serious problem with AI, with the technology access and innovations, whereas we know science and technology and innovation is critical in dealing with climate change challenges as well as environment. So issues around states' obligation, for instance, in UNFCCC and the Paris Agreement about sharing of an exchange of science, innovation, and technology to developing countries will obviously come up. Dr. Ogedi, the adoption of AI into dealing with climate change. I know, for instance, Kenya is currently working on the Kenya National AI Strategy, and I think they were sitting somewhere in Nairobi last week. So it's good we will be seeing probably what they will come up with to address some of the issues that you have raised and the opportunities that AI presents in the process. Now, as to Ogada's presentation, and I had hoped that Professor Mbote will be here, Ogada's presentation invites us to think about, yes, during presentation, but I will give her a chance. But I'm a good student, so I hope I can contextualize this. Now, Ogada's presentation was on indigenous rights, norms and informal norms around communities, and he said about how communities have been preserving water, how communities have been dealing with all these issues. And the question I think he invites us to look is to go beyond the norms, beyond the formal norms that we are used to, go beyond law and invite other strategies, religious organizations, cultural norms, customs. What role do these ideas have to bring into the table in addressing climate and environmental issues? And I know there will be a session tomorrow around it, but what Ogada then invites us is that we need to include these norms, we need to include indigenous knowledge, we need to include cultural heritage and cultural organization of society, and see what role those aspects would play in dealing with climate change and access to justice in that regard. Okay, so from there, I will ask that we take a few interventions and questions to the presenters who've been presenting. Please be kind enough to be very short. One question, direct your question to a specific person so we are able to move very fast. Please, may I see by a show of hands who has questions? Thank you.
Sorry, we cannot hear. Sorry to stop you. I cannot hear anything. Sorry, Professor, to stop you. Oh, sorry.
Don't stop the professor.
I'm sorry.
If you know what I mean, Ogendi. So what I was saying was that when we talk about local norms and we talk about local knowledge, there is the session in the morning when we were talking about science and policy. And I think there was from the handbook, the citizen science. And the question is, I think it is something to mull over, how does local knowing become scientific knowledge? And I'm asking this because if you look at many of the biomes that we are relying on for sequestering, storing carbon, many of them have indigenous peoples. So they must know something we don't know. So how does what they know get into our mainstream of what we call science?
Thank you. Professor Pielo?
To Evans first, I hear you about culture, but my fear sometimes is that in glorifying culture, we are tempted to imagine that culture is what our ancestors did 100 years ago. And very quickly to Dr. Ogendi, when you talk about eco-friendly food production and you are suggesting to us that we should embrace eating meat from laboratories, how are you reconciling that with the movement about against genetically modified food production and of course organic agriculture? And lastly, when you talk about, and this is something that we've been discussing with Professor Mbote about this transition, when you are transiting, for example, from climate and friendly fossil fuel into the realm of lithium batteries and other things, do we ever imagine that a few years' time we'll have a problem of how to dispose of them, and that will have impact on the climate? Thank you.
Thank you. Thank you very much for short, precise, but thought-provoking questions. If we could please be motivated on this side, on my right, please. If we could be motivated or inspired by Professor PLO, we would have our tea in the next 5 minutes.
My question goes to Dr. Ogendi.
Professor, please, I shouldn't be stopping professors, but please state your name.
Okay, my name is Gilbert Oboyere from Egerton University. I would like to have a rejoinder to what Professor PLO Lumumba just mentioned with a different view with regard to AI and food production. And I would like Dr. Ogendi to employ this and look at sovereignty of food production systems and how we will link this to food security when we transfer our food production to other jurisdictions where we don't have control over. Thank you.
Very much. Dr. Kituku, I'm hoping you are asking the other participants that haven't gotten a question.
Yes, very briefly. One goes to either Samuel or Muriuki, role of technology in addressing land injustices, yeah, and speeding up reforms. We've been at it for, I think, 10 years, but are we seeing any results? Then for Dr. Ogendi, he's presented AI as the best thing ever to happen to us, but isn't it problematic for climate change as well? We have around